Former Vice President Atiku Abubakar has voiced strong criticism against a recent court order halting financial allocations to Rivers State, warning it could destabilize the state. In a statement released by his media advisor, Paul Ibe, Atiku questioned the rationale behind the judge's decision to issue an injunction while the case is still pending before the Supreme Court. He alleged that certain elements within President Bola Tinubu's administration had influenced the judgment in an attempt to undermine the authority of the Supreme Court. Atiku commended the Chief Justice of Nigeria, Justice Kudirat Kekereekun, for summoning judges handling the Rivers State cases, urging that only judges found at fault be disciplined to uphold judiciary's integrity and restore public confidence. And to unpack this, we're joined by a lawyer, Henry Ekine. Good afternoon. Glad to have you join me on the news.
Good afternoon. Thank you for having me. It's my pleasure to be on your news.
All right. So let me kick off by asking what your thoughts are on the Federal High Court ruling that the CBN, Central Bank of Nigeria, should cease allocation to Rivers State.
My personal reaction would be that it's unfortunate, but with respect to the consideration of the Honorable Justice Joyce of the Federal High Court of Abuja, I think that we should have been a little more pragmatic with considering the effect of certain decisions of courts that will be made. Judges are not isolated from society. And again, especially when considering the avoidable and unnecessary orchestrated crisis in the legislature in Rivers State that citizens in this country are quite abreast of, including judges, particularly the Federal High Court. One would have imagined that judges should be aware of the various stages of the various matters in relation to those subject matters in court, up to the Supreme Court. So I particularly think that that judgment should have been considered otherwise, but with respect to the wisdom of the Honorable Justice Joyce. And I think, again, that we should come to a point where these issues, the remote issues really, in the crisis in Rivers State House of Assembly, should be addressed frontally, I mean, once and for all. And the Nigerian judiciary should be able to be upright and pragmatic in this regard. We can't go the roundabout way that some of these decisions have come about, and then where judges will carefully, selectively look at certain peripheral issues around the crux of the matter, and then make decisions that will leave citizens and supporters of the various leanings to make interpretations and inferences and imply what the courts will not clearly pronounce. So for me, I think it's come to the point where the Nigerian judiciary should make a clear pronouncement with the specific effect of the defection of the former 27 lawmakers in the University House of Assembly. That's the crux of the matter. Well, because when the judge premised the decision on the ground that the governor could not have presented the appropriation bill before the Rivers State House of Assembly consisting of 4 members, then it means that that court was going the roundabout way to have a touch on the central issue of the defection of 27 former law members of the House.
Just to chip in there quickly.
So I think it's really disturbing in my view.
Okay, because of our time, and then I still have a couple of questions for you. You touched on the court ruling, but some persons will say there was another court ruling saying that that lower court does not have the power to adjudicate in that regard. But then let me understand what your thoughts are. We understand the court ruling is being appealed, the one regarding the CBN seizing allocation to Rivers State. What are your thoughts on how that ruling would turn out?
We are preempting the Court of Appeal. I think I would only speak to the effect that a dissatisfied party to any decision has a right to appeal against that decision. And it's important to understand this. But I think for me, I'm excited to hear that an appeal has already been filed before the registry of the court. And then that should be immediate, especially considering the adverse effect of that decision yesterday on governance in Rivers State. Not just about the governor. This is not a decision that affects the governor or even the politicians in Rivers State, but it's actually an affront against Rivers State entirely. So whether the old woman in my village or the woman in Sangama or anywhere or any part of Rivers State, even public servants, civil servants, children, immunization, access to healthcare, women who are pregnant, how is this going to affect them for them to access maybe antenatal healthcare? And all children in schools. Because if a state is grounded, this is the first time I must say that a court in Nigeria has actually ordered the restraining allocation of funds to any state. Some mistake this to what happened in Lagos. In the case of Lagos, it wasn't entirely the case of the allocation to the state, but perhaps about local councils and then local government. But to direct that revenue should not be appropriated or allocated to an entire state, we mean grounding this administration in the state, and everything and everybody will have to suffer. So I think we need to look at issues when politicians are ventilating their grievances and pursuing their personal interests in this regard. How is this going to affect the greater proportion of the population that will be affected by a decision, particularly this decision in Rivers State? It's not about the governor, it's not about the politicians, it's not about the contestations to the leadership of the Rivers House of Assembly, but it's about the entire administration and governance in Rivers State, the lives of people who are resident even here. Governance is beyond politics. It is about the welfare of all the citizens in Rivers State. So if projects are to be executed, they could be stalled. If administration can't continue, no subvention, no overhead, then administration will be stalled.
Just to follow your line of thought, Mr. Ekine. Yes, just to follow your line of thought, you talked about, this, court ruling by the Federal High Court, ruling to cease allocation to Rivers State. But some persons have said the governor himself of Rivers State, and that's Governor Siminalayi Fubara, violated 4 existing court orders. What do you make of that?
Well, I am not aware, I am not the spokesperson to the governor. I am not aware of any court judgment that the governor has violated. But again, assuming without conceding that there is a disobedience to any court order, I think our rules, judgment enforcement rules and our legislations are clear as to what should be done where any individual or authority disobeys the order of court. In the case of a governor, not specifically about Sim Fubara, any governor in that regard, if a governor is contemptuous, disobeying any order of court, the rules that could apply, I'm afraid, especially with the provision in the Constitution as to immunity, can you prosecute a governor? I doubt at the moment. So, but to the best of my knowledge, to respond to your question directly, I'm not aware. I think those who are alleging should be able to say what specific decision that the governor has disobeyed. And let us also not sweep aside the conflicting decisions and judgments in all of these matters. So if you have a judgment, Bola, and then there is another judgment, and you obey the particular judgment, it is only the other person who considers that other judgment favorable to him that will cry out that you're disobeying that judgment. Because take particularly some of these decisions in Rivers State, there are decisions of court, and they're also valid. When you even raise the issue as to whether a lower court had the jurisdiction to entertain a matter, maybe a state high court, that judgment by that state high court is valid until it is set aside by a court of appeal. So it is not by the pronouncement of an individual who says, oh, a high court didn't have jurisdiction to entertain this matter. But if there is a judgment or an order by that state high court, it is valid until a court of appeal so sets it aside. So if anybody who has to comply with that judgment, complies with that judgment, and there's a conflicting judgment elsewhere, and then it didn't comply, it's disobeying. So if it's disobeying judgment A and is complying with judgment B, when and at what point would we clear all of these controversies that conflicting judgments of courts will create deliberately for political interest and political purposes, than just to vilify somebody that is always disobeying orders of court?
Well, indeed, we hope a lasting solution is found between the godfather and his godson, talking about Nyesom Wike and, of course, Sim Fubara. But thank you so much for your insight on the news. Henry Ekine, a lawyer. Many thanks indeed for your insights.